Thank you so much for joining me today. I am Sam Hayes, and this is Why with One Stop. Today, we're going to talk about too many words. Are you practicing law without a license? Anytime that you add anything to a contract or do anything that deals with contracts in the state of California, it can be seen as practicing law. So, we're going to go through some of the issues I've seen and problems that can come up on files. But as always, verify all with the broker of record of the file that you're working on. A little bit about me. I've been doing this for over 2 decades for files of compliance and file documentation, over 7,000 transactions, risk management focused TC. I've got all the alphabet soup behind my name. I'm a licensed realtor, but again, not a broker yet. So make sure you're verifying with the broker of record of the file you are working on of anything I share with you. And always call CAR Legal if you have any other questions. So the biggest issue that we've got is we've got a California business code, and this is about the unlawful practice of law. So this is saying that if you are holding yourself out there in any way, shape, or form that can be construed that you are giving legal advice that includes adding and working on contracts, that you are now practicing law potentially. And this can be guilty of a misdemeanor or a fine or both. And if you get caught a second time, then we're looking at 90 days in jail and then other issues and all that fun stuff. So this really does have implications that we forget sometimes. Well, I'm a realtor. Well, I'm just doing the contract. I'm following what I've got from CAR. Well, that's why we have to be very careful and make sure we're staying within the documents that are provided by CAR while we use CAR forms because they are vetted. You have a protection from being a member of the California Association of Realtor and using the most current up-to-date version. A lot of times people go, well, does it matter? It does matter. Your E&O typically will not cover you unless you are using the most current form. So on top of practicing law, then you might not have E&O coverage. It can be a huge mess. So this stuff that it's little nitty gritty things that I have people freak out on, including phones that don't work. It's definitely one of the things where you've got to go ahead and just make sure that you're being aware and documenting as much as possible. It's not a Zoom unless I have something go wrong. So with that, make sure that you are double checking with your broker and your verbiage and everything else for it. Directly from the DRE. Typical licensee should note that extensive rewriting of any standard form's language, not the form, but even the language, is not advised and could be construed as unauthorized practice of law. Specific contract provisions relating to buyers and sellers in unique situations should be outlined using the appropriate spaces provided in the standard forms or by using additional forms such as counteroffers and addendums. Okay, so they've already acknowledged that there's an issue about this. And to mitigate some of the liability for agents, when they revised the RPA the last time, when we got the grid set up, where 3L through was 3L3. Well, no, it's actually back it up. It's all the way to like 3E3 through 3PNK, I think is where it ends up. All of those letters, all those sections that are in the grid, they restricted how much you can add to the contract for a reason. There were too many times that agents were adding verbiage, doing too much flowery kind of trying to be a lawyer, make sure they're wrapping everything in there when there's no need. We want to be very factual. We want to be to the point and very direct. One of the other issues that comes up a lot of times is adding things that are out of date. Like a lot of times you'll see on an agent's visual, which was an older practice of make sure you verify all by having a physical inspector, or they should have an inspector check this out and blah, 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 blah. Well, all of that's on page 1 of the AVID. That verbiage is all there for you to review. So by adding more, you're almost taking away and counteracting some of the verbiage that's in place for you by the lawyers at CAR that we pay them for. You want to keep it short, sweet, simple, to the point. It's all about facts. It's all about making sure you get to nitty-gritty details, but not descriptive. So what does that mean? What are we talking about? Well, when you're going into saying the seller's going to do blah, 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 we're going to add 3 extra days here, but only if it's subject to them actually agreeing to this contingency. But then no, that's just too much. 3 additional days to be added to the contract, buyer and seller to agree prior to contingency removal as of RPA 3L3. Really basic. You want to circle back to any time that there's verbiage in the contracts. So you're not doing this, what they're talking about, which is adding too much verbiage and practicing law. Well, okay, Sam. So fine. You don't want me to get all this stuff on the forms. Okay, I understand. Fine. I'll get narrowed down on the forms. Well, what about your emails? What about your texts? What about your cover letters that you're sending over? I know that this is a passionate business. We are working with people's emotions. We are dealing with bringing home people to their home place, their dreams. We are making all this stuff happen. And it's involving safety and security and people feeling calm and protected. So agents can get emotional because it's an emotional transaction. What you put into your comm log, what you put into your emails, what you put into your texts can be subpoenaed. Everything you put in there, including snipey comments, including, well, you should have done this better, but since you didn't, now we're going to wait to remove contingencies. Nobody cares. If you need to get some of that out, which I don't, besides yelling at your screen or maybe talking to somebody in your office to help you vent, mentor, be careful about what you are putting in writing. That is stuff that is going to go to court. I can't prove hearsay. I can't prove a verbal conversation unless you got recorded, which also something to be aware of. Make sure you're retaining your professionalism every time you are interacting with a client, with a vendor. Look at every single document that it could go to court. Even when you're doing a back and forth with somebody that you feel comfortable with, your TC or your escrow officer that you've been buddies for forever. I've seen that be a problem where no, it didn't go to the buyer side, but your entire comm log got picked up and they got asked, well, hey, did you send this or did you do that? Well, give me that comm log. And there's a snipey comment to escrow or there's a snipey comment to the buyer that you're talking about on the other side. Don't do it. Do not put it in writing. If you are not willing to stand up in court and defend and talk about what you're doing, do not put it in writing. As you can see here, going through all the different things of how long they need to hold on to stuff. Typically, you're saying 3 years. Fraud has no statute of limitations. Well, how do you prove you didn't do fraud? You keep your comm logs. I've got comm logs for my clients all the way back to 2007, actually 2003 for some of them. I started scanning in files to have electronic copies so we had access because dealing with ordering stuff, if anybody remembers back from what was it, Stone Mountain? Iron Mountain, excuse me, Iron Mountain, when you'd have to wait and order the box and then everybody's stressing and you're getting more upset. I am a big fan of having everything electronic. It's also why I encourage and request that anybody I work with CC me on all their communication. I save every single email that I receive and I build those into a giant PDF that has the attachments embedded. So we have this communication log to prove. And it's also why I'm constantly in talking to my clients and talking on these videos, circle back. One of the biggest gifts my mom gave me, because she was also in the industry, was circle back, close the loop. And I didn't get it when I first started this. I was like, well, what's the point? They know I did it. They hired me to do it. They should trust me to do it. But we all have these little voices. And you know what? By closing that loop, I've taken some brain noise away from my client. I've got it documented so we know it's all done. I've looped everybody in at what the plan is. Everybody can move forward. I've given everybody back some spoons if you do spoon theory so you can work on this together. It's really important. Well, I talked to my client, it's fine. I can't prove in 3 months when everybody's forgotten and now we got a water main break that you guys told them to investigate that. I can do it if there's an email saying, hey, thank you so much today, buyer, seller, vendor, escrow, whatever. Thank you so much for our conversation today. I just want to recap what we talked about. Blah, 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 blah. I'm going to do blah, 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 blah. You're going to do blah, 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 blah. Thanks so much. Could you please confirm receipt of this email? Even if they don't, we've got it then time, date stamped. You put it in writing. It's within, trying to do it with 24 hours is always your best goal. And we can go ahead and prove this. And we've got all this information, and that's what matters. So that's why I'm always going to say, be very careful about what you're saying, or I will call up and freak out on my clients. What did you say? We can't do, what are you doing? Stop it. We're going to jail. I am definitely known for doing that as well. Because I'd rather you were mad at me and frustrated with me for 30 minutes and we clean something up and you can move on and you don't have this file follow you for the next 90 days, 9 months, and we're dealing with potential litigation. And that impacts your job. That impacts how you're able to think about stuff. And it's a constant stressor. We're all under enough stress right now. We do not need that. So that's my goal is let's get clean and clear on our communication, very to the point. Save the flowery stuff for, when you're going, hey, I want to talk to you, or, well, I'm so excited to work with you. That's great. But let's keep it to the point. Let's keep it very tidy, very tight. It's really, you're going to be your best practice. But again, always verify with your broker of record and legal on your side. This goes into more again, talking about how that communication is not privileged. There's not a privileged confidentiality between you two. That's also in the market condition advisory and why I encourage highly for everybody to use it. Offers are not confidential. Communication happens. So this makes sure that this is outlined, that you're paying attention to it. What if they start the communication? It doesn't matter if they're the one being, if they start the name calling, they were the problem. Let them be the problem. You're just going to have it documented that they were the problem. Why answer back to it? I know you want, I know it's frustrating. I get it. I have sat here with screaming red flames, if you've seen Clue, flames on the side of my face. Don't do it. You got to be the higher person. It's paid off too many times. You've got to just walk away. You've got to not buy into it. There's so many emotions flying. Keep it together. And as they say here, always be closing, always be cobblering for those of us that like Saturday Night Live. But the ABP, always be professional. Are you going to be able to defend this in court? You're going to want to make sure you can. So where are we watching? What are we all concerned about? You've got to watch your contracts. You got to watch your counters. That's your addendums. That's your extension of time addendums. That's if you use an AEA, make sure, you're giving a time frame on this. This is a regular addendum. A request for repairs. Just tell them where it is and include the inspections. Or if you just want a credit, just a credit. Short, sweet, and simple. Agents visuals, same thing. You are not an expert. You are not a physical inspector. If you see a stain on a wall, you see a stain. You don't know what that stain is. You don't know what caused that stain. You don't know how large that stain is, because what could be large to you could be small to somebody else. You don't know any of that stuff. So what you need to do is say stain on wall over fireplace, stain on wall by kitchen door. Whatever can get it is narrowed down and focused on where to find it, but don't describe it. Don't get into details. It's a stain. It's just the facts. What is the fact things that you can back up that there's no question about, no matter what decision gets made or what gets found out about it? Final walkthrough, same thing. Well, we're not going to sign that because you said we didn't fix this and we fixed that and we didn't do. The final walkthrough is to recap that the property is in the same state as it was at the time of offer, or that the request for repairs, if there were any, have been completed prior to close of escrow. That is all the walkthrough is for. It is to recap and make sure what you said you were buying and what you might have negotiated as being bought and changes to it all got done. It's not to start tearing apart. Well, we wanted this planter, or this plant doesn't look as healthy as it did, or this, that. No, that's just, this is what it's at. This is where you're at. This is supposed to check, is everything still the same or kept in the same manner? If it's not, then it's definitely worth it. The seller and buyer signing that off, the form itself is not the requirement. The form, just like an agent's visual, is to meet the contractual civil code of being able to inspect and investigate and then document it. It's not a required thing. So you can push back and forth about who has to sign. Well, my broker. What does the contract say? What does the civil code say? What is statutory disclosure? That's what we're going to constantly be circling back to. Again, facts, bullet points, contractual timeframes, contractual agreements. Stay tight with your words and how you're doing this. Emails, as we just talked about, be careful. Don't tear somebody a new one in writing. Bad practice. Text count, same thing. Your cover letters that you're sending over. Watch what you're saying. Watch what you're doing. As usual, oh my goodness, itchy nose. As usual, I am happy to talk about this stuff till I am blue in the face. It's definitely something I'm passionate about. If you want, I can go into details about each different form, how to go tear them apart. What are you looking for? I'm going to include in the email out to everybody afterwards. You can bounce me an email afterwards if you'd like, for copies of all the different documents that I use to reference for this. I will also have them linked up when I post this on YouTube here in a little bit. And I also have them in my Facebook group, One Stop TC on Facebook. Everything's at One Stop TC and all social media. As always, I'm Sam Hayes. Thank you for joining me for Why with One Stop. If this wasn't a topic you're interested in, please make sure you check out my YouTube channel for other topics, or feel free to email or call me with any questions or another topic you'd like to discuss. Always verify all with the broker of record of the file you're working on. Have a great day. Thanks for joining me.